position which you and I will recognize as actually the correct legal position. Namely, that the power to appoint is quintessentially executive. Of course, it takes one guy to look at the appointees and say, this is my choice for the position. That is actually correct. And yet, there was a dissenting opinion from Oliver Wendell Holmes, you know, the great exponent of American legal realism, attacking the formalism of the Philippine Court. The great ordinances of the Constitution do not establish and divide fields of black and white. But in fact, these powers terminate in a penumbra shading gradually from one extreme to the other. He objects to the sense that there is a mathematical line between legislative and executive power, dividing them into water type proposals. Notice, what he is attacking is actually the dominant approach today. You know, the intellectual ambition of the Filipino lawyer to draw bright line distinctions all over. And yet, it figured in a rejection by the American Supreme Court of a Philippine court decision. Carino versus Insular Government. This is the first Philippine case defending the rights of indigenous peoples. Carino was Ibalon. Well, I will use the word Igorot. I have asked my students who are Igorot, and they say they do not consider it a derising term. And I recommended that guy actually to Harvard. He's back. Mateo Carino claimed the land that the Americans, well, basically at that time sequestered as Baguio City. And he challenged the takeover all the way to the U.S. Supreme Court. And he won. And I don't know, Professor Laretta, if you're aware of it, but his lawyers were the Cuder brothers. Cuder was one of the largest law firms in the world until they dissolved about 5 years ago. But it is a wonder that a chieftain from Baguio was able to hire an American law firm. But apparently they got a share of the proceeds. Again, basically, this was a straightforward formalist position by the Philippine Supreme Court. And who reversed the Philippine Supreme Court? The legal realist Oliver Wendell Holmes. The Supreme Court said to the chieftain, well, chief, if you claim the land, show me your title. The chief said, I'm sorry, I have no title. I never registered the land. And the Philippine Supreme Court says, well, we've got a government of laws and not of men. Show me a title and it's yours. Without a title, you're a trespasser. And this is what Oliver Wendell Holmes said. He says, how can the natives be bound by ceremonies they never heard of? And then he says, in effect, when Spain passed the law that in order to own the land you have to register, when the deadline passed, according to Oliver Wendell Holmes, the effect was that Mateo Carino was living on his house, the house that his family had occupied for generations. And when the deadline passed, overnight he was transformed into a trespasser in his own house. That is the legal effect. And again, it took an American justice to reject the formalism of the Philippine Supreme Court. So notice, here there is a fundamental claim of justice. The Philippine Supreme Court was completely blind to the injustice that it was doing, and it took a different legal approach, legal realism, to say that, hey, what we're doing here is really wrong. Maybe we should find a way to correct it. And it took the legal realist position to find the solution and to reject the formalist position taken by the Philippine Supreme Court. So, I now go to the topic of why is it that we have arrived at this extreme formalism? And then I will give you the other side later. I go to a classic metaphor in legal theory, von Gering's heaven of legal concepts. He was a leading figuratician, born in the 1800s in Germany. And he developed a jurisprudence of concepts. The idea that law will have its own systemic and systematical framework. That everything you say within that law should be capable of susceptible of finding its proper place within that structure. And I invite you to go. Again, I ask the gentleman at the back, can you read this? Chas, you're my test case. Can you read the... Okay, if Chas can't read it, I will read it for you. Thank you, Chas. So, he was a theoretician. And you know, Germans are highly formalist. He said that this German theoretician had a curious dream. He died and went to a special heaven reserved for the theoreticians of law. In this heaven, one met face to face the many concepts of jurisprudence in their absolute purity, freed from all entangling alliances with human life. Here were the disembodied spirits of good faith, bad faith, property, possession, latches, rights, the stuff that you study. Here are all the legal instruments needed to manipulate and transform these legal concepts. Here one found and I love this metaphor, a dialectic hydraulic interpretation press, you know, an imaginary machine, which could press an indefinite number of meanings out of any text or statute. An apparatus for constructing fictions, and a hair-splitting machine that could divide a single hair into almost 1 million equal parts. And when operated by the most expert jurists, can split each of these parts again into another 1 million parts. The boundless opportunities of this heaven of legal concepts were open to all properly qualified jurists, like your professors in the College of Law. Maybe that's the only heaven you will qualify for. Provided only that they drank from the leaven draught, some sort of beer, which induced forgetfulness of terrestrial human affairs. And this is the catch. But for the most accomplished jurists, the Lethean draught was entirely superfluous. They had nothing to forget. In other words, the tendency in the heaven of legal concepts is to teach law completely, to teach the doctrines of law, as rising above the facts, and to be completely oblivious of the facts. In American law, they call this bar law. You know, factual questions which never really arise in real life, and which are meant just to test your multiple choice capabilities. But before you think that this is actually grand theorizing, it is not, because this is the article from which it came. So the excerpt I showed you was here to here. But notice the bottom. The bottom question is, you can't read it from there, what is a corporation? And then he speaks about the legal fiction of corporate legal personality. In other words, he begins with high theory, and then after the high theory, he begins to implement it into all the legal fictions created by law. So it's my way of saying that, that what I'm doing now is a rejection of, by Professor Harvard, calls it Mandarin theorizing. Theorizing about law, which is self-conscious. So if you ask me, is law an extension of moral judgment? And then I tell you, well, it can be a moral judgment, it can be a reflection of power. There's a big theory. Here we root the law in decisions like Springer and Carino. But notice the persistence of this approach. These are quotations from the current U.S. Chief Justice, John Roberts. During his confirmation hearings. And he really won. He won over the votes in the Senate. He won his confirmation. Judges and justices are servants of the law, not the other way around. So notice, you can imagine these words being uttered by a Pinoy. Judges are like umpires. They don't make rules, they merely apply it. They merely make sure that everybody plays by the rules. Because nobody ever went to a ball game to see the umpire. You know, it's like going to Araneta Coliseum, watching a basketball game, and the whole time you're watching the referee. You know, galing ng referee. And he says, I will decide every case based on the record, according to the rule of law, without fear or favor, to the best of my ability. Again, guys, you can imagine a Pinoy judge saying this, agreeing with it, and all of us applauding. That is what they're supposed to do. My job is to call the balls and strikes and not to pitch or bat. Baseball is not really a Pinoy game. Although it was famous actually before the Second World War. But there's a whole field of debate in the U.S. on why legal debates often resort to baseball metaphors. And this is a metaphor I got from Professor Lauretta. And every version by the umpire shows a different approach to the application of rules. The first one says, I call them as they are. The second says, I call them as I see them. And the third one says, they ain't nothing till I call them. So notice, I call them as they are assumes that there is a fixed meaning to the rules objectively existing within the text. I will call that the formalist approach, at least for our purposes this morning. The second, I call them as I see them, assumes the subjectivity of the judge. And the third, I will take to be the more legal rigorous. It shows that the rules are what the adjudicators, well, the Constitution is what the judges say it is, says it is. And this is a quote from Robert Jackson for my students in PIL. This is Jackson arguing before the Nuremberg Tribunal, saying that, guys, when we reverse lower court decisions, don't think that it's because we're smarter than them. It's just because we're a more powerful court. And the classic quotation is that we are not final because we are infallible, we are infallible only because we are final. Notice, it is an emphasis, therefore, not on the correctness or the moral superiority of reasoning or moral superiority of a judgment. It is merely an emphasis on the power to decide. So in part one, I began with the legal realist, self-image of Philippine law, at least for Malcolm Hall. For part two, I focused on the Philippine decisions, which show a deep-seated formalism. And for the third, I show the manipulation of legal formalism to suit desired legal outcomes. And I will use as my main example the most famous graduate of the UP College of Law, class of 1939, Ferdinand Marcos. And when Marcos declared martial law according to Professor Lauretta, classes were suspended for how many months, Professor? 3 months. For 3 months. And during those 3 months, that is when... Well, I am glad that you react very differently. Well, in fact, I think that's exactly how Professor Lauretta reacted. He took up running, and he became a marathon runner. Really, he has run 42K marathons, Professor. 3 times. He still runs today. Just to show you his influence on me, he actually got me hooked on running. But I never ran a full marathon. Well, I always dreamed of doing so. But, okay. I will show you the way legal formalism was used by Marcos and the Perfecto Fernandez approach on that legal formalism. The 1971 suspension of the writ of habeas corpus triggered off by the throwing of a grenade at the Plaza Miranda rally of the Liberal Party. It almost killed Senator Salonga. And the Liberal Party went on to sweep the 71 senatorial elections. Notice by 72, Marcos will declare martial. So after the bombing, he suspended the writ of habeas corpus, and it was challenged before the Supreme Court. And it was upheld by the court in Lansang versus Garcia. Well, basically, you have encountered this decision in your con law classes. The court says, until Dansa, the position was, when the president exercises the commander-in-chief power to suspend the writ of habeas corpus, that is a political question, non-justiciable, and will not be reviewed by the courts. Dansa abandoned that principle. Dansa says, from now on, we will review the commander-in-chief powers, not on the basis of their correctness, but on the basis of their validity. Not the test of correctness, but the test of arbitrariness. And that's so long as it is supported by enough facts, we're okay. That was the heart of Dansa versus Garcia. And it turns out that there was a tentative decision by the court upholding the suspension of the writ, and then it became unanimous. I stumbled on the Marcos diaries. The diary of a dictator. This is the handwriting of Mamoy. And Mamoy was a very philosophical guy. Look at this, I don't know if you can see it here. He says, reflections. What is my central purpose in life? I am president, comma, I'm the most powerful man in the Philippines, comma. All that I have reached off, I have, etc. So, this was what people did before Facebook. They wrote with their own hand on a piece of paper. It turns out Marcos had a mole inside the Supreme Court. We will discover it to be Fred Luis Castro. And Castro would update Marcos about the discussions of Dansa versus Garcia. Marcos monitored the deliberations. He wanted the decision to be unanimous. In fact, he asked Fred Luis Castro, what will I do to make this decision unanimous? And Castro told him, why don't you have a partial lifting of the writ? Just a demonstration of good faith. And he says, we have an en-banc hearing on Monday. You lift it on a Saturday, it hits the headlines Saturday, Sunday, and Monday, and by the time we have the en-banc, it is easier for me to convince others. And when eventually it became unanimous, this was the reaction of Marcos. He was euphoric. The biggest legal victory. It is electrifying. And Marcos, but notice that his conclusion. This means I can place the Philippines under martial law. So notice, the legal formalists rejoiced at Lansang versus Garcia. But the legal formalists said that, hooray, the courts will now be able to review a commander-in-chief exercise by the president. And yet, there was a different reaction from the part of Macoy. If necessary, it can formally declare a revolutionary government and even disregard the actions of the Supreme Court. And he says, they insisted that we retain a color of constitutionality for everything that we do. They do not understand that a new day has come. And he would, so if Lansang was the high moment for civil liberties and for the formal constraint upon presidential discretion, why was it good news for Macoy? So there is a gap between the formalist position and the realist position. And this was the response of Professor Fernandez. The court actually adopted a minimum test of validity, namely whether the decision was totally arbitrary, bereft of any factual basis. So, Perfectus' theory was this. How do you establish arbitrariness? Then you say that, well, you suspended the writ. He invoked a communist conspiracy. And we don't really have evidence of the conspiracy. And then he said, Perfectus asks, where do you derive, anyway, the proof of a conspiracy? Marcos was commander-in-chief. You will get it from the generals the subordinates of Marcos. And so, Perfectus' theory was, of course, if the court says, we now have the power to review, but the standard of review is very low, you will end up always ratifying the exercise of executive power. This is pursued in Javeliana versus Executive Secretary. You're familiar with the story. It's the longest case to be assigned in constitutional law. I will not go into detail, but I will show you the quotes from the justices. They basically said, yes, sure, they did follow the Constitution. Yes, sure, it was a bogus ratification. One justice even said that in my own neighborhood, there was no such citizen assembly. But the court eventually said, regardless of how it was ratified, even if it deviates from the old Constitution, once ratified by the people, it's out of our hands. Because, in fact, had the people risen up in the revolution, what would we have done? We would have validated. Why make a distinction now that the court did it peacefully? So, two strains of legal reasoning in Lansang and Javeliana. Lansang, on its face, was highly formalistic. Javeliana, on its face, was heavily legal realist. And again, Perfecto Fernandez says, he had an essay at that time. The minority in Javeliana applied the test of strict legality. The majority applied the test of political reality. But notice, Javeliana, so notice, Lansang was praised because it was a highly formalist decision. It was pro-civil liberties, that's Lansang. Javeliana was criticized because it violated the rules of formalism. And I still remember my professor in political law was Miriam Defensor Santiago, then a young, that was before she became, even before she became a judge. My professor in persons was Yorap. Both of them would criticize Javeliana. They said in Javeliana the court did not follow the law. And yet the strange thing is, when Cory Aquino took over, that is exactly how the Supreme Court ratified the Aquino government. It was a deja vu of the Javeliana decision. Her right to power was not due to constitutional powers. In fact, it was in violation of the 17th Constitution. And the people having accepted Cory, her legitimacy was not justiciable, but belonged to the realm of politics, where only the people judge. So notice, if you look at Philippine history, we have the shifts from the highly formalist tendency toward a heavily consequentialist reasoning. In other words, sometimes we like strict legality, sometimes we like political reality. I will now deal with one possible constraint upon that tendency. Jorge Bohol, the father of the of the civil code of the Philippines. These are classical Bohobo clauses. Every time you see contrary to law, public policy, public order, public policy, morals or good customs, you can be pretty sure that was a Bohobo contribution to the civil code. Notice that if you were a strict, he codified it already, that's the dilemma. Having codified it, even if you were a strict formalist, you will have to apply morals and good customs. But from the traditional standpoint, if you codify the binding character of morals and good customs, the question is, where does the judge get those rules? The judge can basically concoct a rule. It will be the, if you have a very conservative judge, it will be conservative morals that he will apply. The classic example, the most recent, is the Angladlad case. The Comelec said that Angladlad cannot be certified by the Comelec because they espouse immorality. Because according to Avalos at the time, the chairman of the Comelec, anything gay is sinful. He said that in front of Danton Remoto. And I asked Danton, we were co-speakers the other day, I asked Danton how he reacted to Avalos. Avalos told him, I am denying your certification because as far as I'm concerned, all gays are phantom voters. And then Danton replied, I might be a phantom, but I will still be opera. Well, I got to tell you, I was floored by this because it can't make sense of me. But and he said that Avalos was stumped. It had to be explained to him by the first of what the metaphor meant. But I don't know how to make sense of that metaphor. But anyway, so notice that I spoke too fast, but I really like to hear from Professor Lauretta. So notice, in the Angadad case, the Supreme Court, well, the Comelec applied the morality of Avalos and company, anti-gay, anti-LGBT. But because it was codified into the rules by Bocobo, yeah, it's okay. And it took the Supreme Court to reverse the Comelec ruling. The court this time invoking norms, and this shows you the problem with the Bocobo approach. Human rights norms, which trumped the judgment of the Avalos Comelec. Remember that human rights became codified, especially for you in public international law, became part of international law as part of a natural law crusade. It was a natural law, guys, who kept on saying that there is a morality superior to these rules, and we should codify that morality into binding treaties. And the result are all the human rights treaties that we have dealt with in PIL. My second to the last slide. Shapiro wrote Legality. Teaches at Yale. It's the bullshit that makes all the difference. And so, what is the function of that veneer, the legal veneer? Over either an exercise of power, like Marcos, over a moral choice, like that of Avalos. And for me, it is the quest for legitimacy. So, I take this journey into legal theory as the discussion of the relationship between statutory text, the words of the law, and the desired public policies or moral judgments which are out there, which are the domain of natural law, and the question of power, of the power either to adjudicate and to legislate. And in conclusion, the Pinoy is actually schizoid about rules. We cast our legal analysis in formal language because we need that for legitimacy in official discourse. It is when we translate what is essentially either a partisan view or just an opinion, we have to cast it in the language of law in order to appeal to the legitimating power either of the state or largely of secular. But we need legitimacy in actual life, in day-to-day life. And that is where legal realism comes in. So we switch back and forth. But in the end, it goes back to natural law. In fact, and I would like to close with this point, Professor Loretta. I think Pinoy's, well, natural law was the most congenial legal theory for Catholic doctrine. Because if the natural law says that there is a body of rules out there superior to man-made law, a body of rules which has its own universality, and structure. It's almost custom tailored for Catholic morality. And that is the Pinoy. That is the most natural. And we resort to legal form, to the shifting between legal formalism and legal realism, only because we are actually living out what is the deep-seated natural tendency of the Pinoy, not just of the Pinoy lawyer, but of the Pinoy citizen. Thank you very much. Professor Loretta, you have the floor.
I had a talk with Raul before he delivered his lecture. And he told me that he is going to talk about legal theories in Philippines. One of them will be Dean Malcolm, and Dean Popopo, and the other one is Perfecto Fernandez, who was my contemporary. And the other one was supposed to be Malcolm. And I knew Perfecto rather intimately. We came to the UP in 1949 as freshmen. We inaugurated the UP campus as freshmen in 1949. That must be very long ago. And we were students in the College of Liberal Arts in 1949, and then we came to the College of Law together. And so maybe what I'm going to I prepared my remarks, and the reason for that is because 14 years ago I suffered a stroke which impaired my speech center, and so I had to prepare my remarks in writing, because according to my neurologist, speech to me is no longer instinctive. Holding in my mind, I have to think of every word that I utter. And so I have to have my remarks. And maybe that it is not really relevant to what Raul has said. They're all about Perfecto Fernandez and his achievement as a legal theorist. But nonetheless, I like to read it. Pepe, he was then fondly called Pepe rather than Pecto, and I was recruited in the UP in the same year, 1960. He, as legal counsel of the UP, a position which President Vicente Cinco created for him, which is a measure of President Cinco's abundant respect for Pepe. And I, an instructor of the UP College of Law and secretary of the college. At that time, Pepe and I at the same time, Pepe was simultaneously appointed a lecturer in the UP Law Faculty. In 1960, we were both nearing 29. The office of the UP Legal Counsel was, at that time, located in the second floor of Malcolm Hall. Precisely to enhance inspectors' access to the law library. And my office, and so to my office, also in the second floor. Accordingly, it was convenient for Pecto and myself to meet mostly after office hours in the afternoon to talk about what else? Law and philosophy. Of course, Pecto, and of course, I have known Pecto senior students in the College of Liberal Arts in the early 50s. He was then a staff member of the Collegian and was a prolific writer at that. After reading him once, I became an instant fan. And have been so ever since. What endeared me to Pecto, among others, was that Pecto's heart was on the right side. For like the British socialists in the early 90s, exemplified by Harold Lasky, Pecto's heart bled for the poor, the deprived, the disinherited, and the dispossessed among our people. As you probably are aware, poverty has always been the scourge of society. And the long war against poverty, like the equally long war against criminality, especially among the elite, the senators and the congressmen seem hopelessly unwinnable. My wife finds me somewhat reticent and aloof, and she was fond of saying that the number of individuals who truly counted me as friends cannot exceed the fingers of one hand. I believe that one of those very fine individuals who regarded me as a friend was Pecto. That friendship was a pleasure and an honor which I have always treasured for more than 60 odd years. Today I would like to speak of Pecto's unique achievement as a legal theorist, as a legal philosopher. By the way, as Pecto was wont to say, the history of Philippine law cannot be written without some account of the UP College of Law, however grand and modest an institution it might be in the story. I believe that with the true of the UP College of Law is true as well of Pecto. The history of Philippine law cannot be written without an account of Professor Perfecto Fernandez in this story. Pecto's unique and greatest achievement was that he was able to formulate a conscious, explicitly stated, and coherent theory of law, which is the answer to the ambiguous and unanswerable question, what is law? And what is more, Pecto's legal theory is philosophically respectable. No Filipino lawyer or law professor, living or dead, has been able to do so. Not Justice Florentino Feliciano, whose average grade in the UP College Law is the 7th highest, Feliciano graduated with a average grade of 1.38. And it was succeeded only by my student, Geography, who graduated, he graduated with the average grade of 1.31. Of course, differently from the preference of Raul, the defeat that Geography could defeat that Geography can accomplish is to recite the whole textbook from cover to cover, word for word. I think Raul frowns on memory work. In our day, in political law, for instance, we could only finish 3 cases. And the reason for that is because the professor, Professor Garcia, demanded that we recite the case word for word from beginning to end. And so the class would go from the first row until someone was able to recite the case word for word, punto and comma, from the beginning to end. And so political law consisted of only 3 cases which we recited word for word. And I wondered what was the lesson, what was which is to be imparted by that discipline. And it told me that it is a good thing. But as I like to say my students, to be successful in the country of law, you must develop 3 traits. And these begin with the word D. What's the name? What traits must you develop to be successful in the country of law? 3 words, all beginning with D.
Diligence.
Yeah.
Discipline.
Yeah.
Determination.
Could be. But in my case, in my book, it is diligence, diligence, diligence. And that is what our professors wanted to impart to us by emphasizing memory work. Pedro's unique greatest achievement was that he was able to formulate a conscious, explicitly stated and coherent theory of law. I understand that Pecto wrote a book on jurisprudence, and which was accepted by the Oxford University Press. At the time, during martial law, in order to publish a book, you have to seek the permission of Malacanang. And Malacanang did not give the permit to Pecto. I wonder what became of that book. Not even Florentino Feliciano, not even Justice Fernando, not even JBL. Perhaps in the time Justice Feliciano or Chief Justice Fernando, or perhaps JBL themselves, were always men of affairs, too preoccupied with the actual and life issues of Philippine law and politics, which would be momentous and difficult and impractical to be bothered with mere theory. Alas, Feliciano and Fernando, and so to perhaps JBL, were reduced by Holmes's admonition to share the passion and actions of the time, or be found or be quoted not to have lived at all. Perhaps the only one who came closest to being able to formulate a legal theory was Dean Bukovo himself. For one could make the argument that Dean Bukovo actually intuited and predated H.L.A. Hart. Whose unique contribution to legal theory was the rule of recognition. And this is embodied in chapter 1 of the Civil Code, beginning with Article 7, all the way up to Article 12. The rule of recognition is a criterion of lawness. What are to count as law in the Philippine legal system? What are they? One of them is enacted law, namely the Constitution and the statutes and every deliberately enacted legislation. And next, it is precedent. They're all embodied in Article 7 up to 12, and also customs. The rules that are supposed to count as law in the Philippine legal system are statutes, among them the Constitution, precedent, as well as custom. And since Dean Bukovo was an advocate of that natural law, and the whole of chapter 2 is the embodiment of natural theory, he also managed to smuggle into the rule of recognition what Holmes says the looming omnipresences in the sky. He starts with Article 9. No judge or court shall decline to render judgment by reason of the silence, obscurity, and insufficiency of the law. In other words, when there is no law, what do you do? The inspiration of Article 9 is Article 1 of the Swiss Civil Code, which reads as follows: when there is no law clearly applicable to the point of issue, or if the law is doubtful, ambiguous, conflicting, and previous judicial decisions do not throw light upon the question. In other words, as Enrique likes to say, when the law has run out. In other words, no law. What will the judge do? And previous judicial decisions do not throw light upon the question, the general and local custom shall govern. In the absence thereof, the judge shall apply the rule which he believes the law-making body would lay down, but it should be guided by the general principles of right and justice. In other words, the judge is to function as a surrogate of the legislator but and you should be guided by right and justice. What Holmes calls the looming omnipresences in the sky. In other words, as far as Philippine laws is concerned, it is the members are the Constitution, the statutes, President, customs, and right and justice. Din Bako is smuggled in because he is an advocate of natural law. And but Din Bako was true to his civilian tradition, and that is that law is the voice. Law is the articulate voice, not of the judge, but of the parliamentarian. A division of inspector was able to formulate a conscious, explicitly stated, coherent theory of law that is philosophically respectable. Was the fact that he was a philosopher, a true philosopher. Spector mastered and embraced the doctrines of the British imperialists, especially David Hume, and as far as I could tell, never look back or after. For those who, like myself, are susceptible to titillations by the passing or the current fashions in legal theory, like the linguistic terms inspired by Wittgenstein's line and XLFR, or the interpretive term powerfully espoused by Dworkin, or the postmodern trends pioneered by Docinas and Warrington, and also by the mathematical term exemplified by law in economics, which according to Grant Gilmore, he charmingly derided as a discipline where the counters don't think and the thinkers don't count. It might interest you to know that during the last 2 decades, philosophy has taken a naturalist turn. And the inspiration for this new fashion in philosophy are precisely David Hume and Friedrich Nietzsche and Willard van Orman Klein of Harvard. We are told that this naturalist turn has spread in every area of philosophy, according to the meta-ethics, philosophy of language, epistemology, American legal philosophy, largely to the efforts of Brian Leiter, perhaps the most sophisticated among today's American legal philosophers. He is both a professor of law and a professor of philosophy, formerly at the University of Texas in Austin, and now at the University of California, perhaps at Berkeley. As I understand it, the central doctrine of naturalism, as articulated by Leiter himself, seems to be this, and I quote, the linguistic turn of the first half of the century, in which traditional philosophical problems were framed as problems about the use of language, has either given over to or been supplemented by the naturalist turn, in which traditional philosophical problems are thought to be insoluble by the a priori armchair methods of the philosopher, and to require instead embedding in or replacement by suitable empirical theory. if naturalism succeeds as a new paradigm in legal theory, Pecto, the exponent of logical positivism, which is completely different from legal positivism, and which perhaps is more aptly named by the late Ricardo, not Ricardo de Pascual of the Philosophy Department of the College of Liberal Arts, as logical empiricist positivism. Pecto is Pecto is a legal philosopher, and could be Pecto as a legal philosopher could be the current fashion in jurisprudence as well. But the way he's passing Pecto could now signal the demise of serious philosophizing about law, or the onset of the dark ages of Philippine jurisprudence, maybe an alarmist. In the dark ages of Philippine jurisprudence, unless younger theories like Raul and Toto Fernando, the son of Justice Fernando, or the current crop of law professors, whether in the PUP or elsewhere, can carry on the baton for Pecto. Now I would like to cite Raul and Toto Fernando as the present crop of legal theories. Raul, I think, is the second Filipino to be awarded an STD by Harvard. The other one, according to Ambion, was awarded before the Second World War. The first to be awarded, and the only one to be awarded by Harvard for a JSD degree is Raul. Salonga began his graduate studies at Harvard, but did not qualify for the JSD program. So he had to satisfy himself with a JSD at Yale. The other one who began his studies and graduate studies at Harvard was Abello. Numani Abello. But like Salonga, he never qualified for the JSD program. And so Manny Abello had to satisfy himself with a JSD in Michigan Law School. And as far as Toto Fernando is concerned, I think he is also an accomplished legal theorist. Toto Fernando is the only two graduates who obtained a DCL in Oxford. The first to be awarded the DCL of Oxford was Melquiades Gamboa. And the other one is Toto Fernando. Comparing Chief Justice Fernando and Toto Fernando, Chief Justice Fernando is supposed to be the prince of constitutional teachers. But he accomplished more by reputation than the actual legal. But where Chief Justice Fernando failed, Toto carried the whole thing. Thank you.
So, Ladies and gentlemen, would you have questions? We have 5 minutes for questions, either for me or for Professor Laureta. Well, thank you, Professor Laureta, for the kind words. Thank you for spending your time with us this morning. And you know, just by way of closing, the day-to-day life in Malcolm Hall actually reflects it has underlying legal philosophies. The idea, like a legal realist professor, for a legal realist professor, there is no single right answer to a question. Like a question will have 2 or 3 possible legal answers, all of them valid, and what you will eventually use depends on the position, on your substantive position. So, a professor who will assume that there is only one right answer to a question is a professor which at that moment has assumed a formalist stance. The nightmarish situation described by Professor Laureta of being made to memorize verbatim a Supreme Court decision. Actually, Professor, I don't know what legal theory underlies that. And I was telling Professor Laureta that I encountered a magna cum laude of the College of Law, Manny Zamora. And Manny would say that, you know, in Professor Estelito Mendoza, I memorized something, recited it for 6 pages verbatim, and I faltered only on page 6 because I missed a comma or a semicolon. And I wanted to ask him, so like, what else did you do? I mean, you memorized. And, but again, it's a generational thing. As Professor Laureta says, we had a whole generation of people who did that, and who still managed to be highly philosophical and very critical. In fact, Professor Laureta says that during his time, none of the professors would accept a teaching assignment on the bar review subjects, civil law review, commercial law review. They all refused those assignments. They preferred to teach the basic course, which my own buds. Again, these are philosophies which actually affect the teaching of law, the arguing before judges, the writing by judges and justices on what they think they ought to be doing, confronted with a dilemma, with a case, and for me, fundamentally, their own definition of what it is to be a good lawyer, what it is to have achieved a lot as a lawyer, and what it is to achieve success in the profession. So, would you have questions? Yes, please, Mike. Just switch on the mic.
Good morning, sir.
Yes.
I have 2 questions, one for you and one for Professor Laureta.
Okay, sir, so we're on. Go on, please.
Yes, sir. My first question is, given that the Filipinos are schizoid about law, do we cure it? Or if we can cure it, how, sir?
Okay, so the question is, if I consider being schizoid a problem,
Yes, sir.
Is there like a solution? I will have a first crack, Mike. Is that also the question for Professor?
No, sir.
Okay, what's your question for Professor?
My question for Professor Laureta, sir. How exactly did you decide on the quotation on the first question?
Well,
Professor.
I have my own holy trinity. The Godfather Wittgenstein, perhaps the greatest philosopher of the 20th century, and the other one is H.L. Hart, God the Son, and the Holy Ghost is Oliver Wendell Holmes. So I worship Holmes almost as a god. And so I was familiar with this quote, and I think that was the truthful for the man who was born.
Thank you.
Thank you, Mr. President.
Thank you, sir. Well, I worship Holmes as well. I have a picture of Holmes in my office. Okay, Mike, your question, is there a cure? You know, other societies have a consensus, have a moral consensus, not really a consensus on legal philosophy, but on moral philosophy. And maybe that is the starting point. For us, we are sort of morally accurate. So they have arrived at that culturally defined range of interpretation. I'll give you a complete example, and I will post this. To get a driver's license in Massachusetts during my time, you would need to take your driving test in the car of a friend. In other words, someone has to trust you enough to let you drive his car. And since I was doing the doctorate, and I was there for many years, and the LLM is just for 1 year, every year, all the new LLMs would borrow my car to test drive. And by the way, you have to be inside the car when they drive it. I got to tell you, every year there was one very common mistake for Pinoy drivers. The rule is, as soon as a pedestrian steps on the road, you stop. That is absolute. It's a full stop. It is the right of way. And I noticed that I always tell that to the Pinoys. I said, look, last year, so-and-so flunked the test. And every year they will follow it. But every year they would, well, many would flunk. Because the idea is that, like, sure, he has right of way. I will slow down, but I won't really stop. You know, it is a very slow crawl, but not a full stop. And as soon as that happens, the guy is sticking up. My point is that for other societies, they have a clear sense that if the rule says right of way, you make a full stop. For us, the idea is that, yeah, sure, I will slow down. He has preference. I expect him to move a bit faster. And then we both end up happy. Or sometimes someone ends up dead. But still, like, in fact, that's the thing. The range of interpretive leeway is something which is culturally determined. And for us, that range is a bit broader than others. So I think if you're looking for the antidote to the schizoid position, I think it is just to arrive at a core enough consensus on how far we can veer away from the text.
Thank you, sir.
Okay. Yeah.
I'm glad that Raul exemplified getting a driver's license in the U.S. My experience is completely the opposite. When I was supposed to be test drive, it happened that that time it was already 11 o'clock, and my car was not air conditioned. That was in 1964, and so the test drive, the one who was testing me said, "Marunong ka bang mag-drive?" I said, "Yes." Sige, paipasalan kita. Are Filipinos is schizoid about law? Is that your question?
They're viewers.
Yes. I ask you, outside of your classroom, do you ever think about the law? Outside of your classroom?
Of course, sir.
Of course you do. In my case, because I practice law, I always think about it, but as a way of making a living. It is important to me because it's a way of making a living. But in your case, I am fascinated by this theory of Austin of habitual obedience. Habitual obedience. According to Dworkin, there are two atmospheres in which we live. the natural atmosphere and the legal atmosphere. For instance, are you a human being?
I think so, sir.
Yeah. Are you a person?
Yes.
Why?
Because, well, sir, do I have to explain, sir?
Yeah, yes, of course. Are you a person?
Yes, sir, because that is how I define myself.
No. You are a person because? Yes, because you are a creature of the law of persons. Without the law, you are not a person. You are a human being. That is well and good. But if you are a person only because the civil code says so, the primacy rules. But also, have you ever thought of raping someone? Of course not. What? Why not? Why not? Is it because you are scared of the penal consequence of the vice criminal code?
Because, sir, the thought itself is revolting.
No. You are, among others, a properly brought up person. In other words, you have been brainwashed by the brainwashing institutions of society. Among them what? The family, and now the schools, and every other institution. As a matter of fact, you know, the principal aim of general education is what? To make you a good citizen. So, for instance, do you take the public transportation?
Yes, sir.
Yeah. Do you pay?
Of course.
Why?
Because it's only fair
Because
to
the law. Of course not. According to Holmes, what? You pay because you imitate. That's what your other persons do, and so you just imitate. Not because of the law, because I'm sure if not, are you familiar with the common carrier?
Yes, sir.
Before you did that, did you nonetheless pay your pay?
Yes, sir.
Of course. Are we schizoid about law? Maybe. But think about it. Think about it seriously. Outside of the classroom, do you ever think about the law? Of course not. You are preoccupied with something like what? The favorite activity of Filipinos. Yes. The favorite activity of Filipinos. Of course not. Texting and
Facebook.
Going to the malls. These are examples of what Hart calls convergent behavior. Have you ever witnessed a crime, like say a robbery or a homicide or something else? Have you ever witnessed something like that?
I have been a victim of theft.
How frequently?
Just once.
Just once. In all, how old are you now?
I'm now 26.
Yeah, and you know why? Because we pay according to Austin habitual obedience to the law. Habitual being unreflective, unreflective as well as instinctive. But of course, law is important. Although you take to the law as if you take it there. Do you breathe air? Of course you do. And you become conscious of the air only when
You think about it.
No, when you're being
Very
choked,
interesting.
or when you're drowning, then you become aware of the air. And you take the same attitude to the joke.